Our latest report deals with two common law offences, false imprisonment and kidnapping. The definitions of these offences have evolved through judicial decision-making over centuries. As a result, they are not as clearly defined as they should be for such serious offences, each carrying a maximum life sentence. Difficulties arise in practice because of this lack of clarity, in the kidnapping offence in particular, and this has led to calls for reform from the appeal courts and others. In our report, Simplification of Criminal Law, Kidnapping and Related Offences, we recommend that the offences should be placed on a statutory footing. There will be a separate new offence of unlawful detention and one of kidnapping, with each defined in clear modern terms. The offence of kidnapping should, we recommend, arise where a person intentionally uses force or threats of force in order to take the victim or cause the victim to move with him. The current range of criminal conduct that is caught by the existing common law offences of false imprisonment and kidnapping will remain criminal under these new statutory provisions. The level of protection against these types of serious wrongdoing will be maintained, with both the new offences triable in the Crown Court and carrying a maximum life sentence. Our recommendations provide definitions that are simple and readily understood, producing greater clarity around the relationship between the offences. This will allow for greater certainty in prosecution decision-making. We also make recommendations to amend the existing statutory offences of child abduction in order to resolve two particular problems that have been recently identified. In the case of Kayani, the Court of Appeal expressed concern that the maximum sentence for child abduction is limited to 7 years. In that case, a father took his child out of the United Kingdom for many years. When they returned, the child refused even to see the mother. Cases like this may not amount to kidnapping, but can involve great cruelty for which the maximum sentence may well be inadequate. We recommend that the maximum sentence be increased to 14 years to allow the courts to deal adequately with the gravest cases. The second problem relating to child abduction was exposed in the case of Nicolau. The Divisional Court held that no child abduction offence is committed when a parent has permission to take his or her child out of the United Kingdom, but keeps the child abroad longer than the permitted time. This is clearly a gap in the law. If it is wrong to take a child out of the jurisdiction of the UK courts, it must also be wrong to keep the child out of the jurisdiction. We therefore recommend that child abduction should be extended to include the case where a child is lawfully removed from the United Kingdom but unlawfully retained abroad. The report is available on our website.